Welcome to today's video. I'm Richard Chapo. I'm a lawyer down in San Diego, California. And today we're talking about final amendments to California Consumer Privacy Act as of September 13, 2019. So the California State Legislature session ended on September 13, 2019. Yes, Friday the 13th. Cue the ominous music. And they were contemplating a number of bills, 7 different bills to amend various aspects of the CCPA. 6 passed, and 1 failed. Ironically, the one that failed was kind of a surprise to me. But nonetheless, this is pretty much it for the amendments to the CCPA for the rest of the year. So we now have some concrete idea what the actual text of the CCPA is going to look like going into 2020. Now, we still have to wait, obviously, for the governor to sign the amendments into law. We don't know how that's going to go. And we also are waiting for the California Attorney General to start issuing regulations regarding CCPA compliance. And we expect that to happen in the next 2 to 3 to 4 weeks. Somewhere around the end of September or the middle of October. Now, that will only be the first draft, essentially, of the regulations. It'll be a proposal, and then there'll be a period where people can comment on it positively or negatively and point out, some issues that maybe the AG hasn't thought about. And then those will be taken into consideration, and then proposed final amendment or final version of the regulation will be proposed, and it'll go on and on and on. But hopefully before the very end of 2020 or maybe just into 2020, we'll get that final regulation. Yes, right around the time that the act actually goes into effect. Welcome to California. So what actually happened with the amendments? So AB 1355 passed. Now, AB refers to Assembly Bill, if you're wondering. It's one of the houses of the California State Legislature. And it exempts de-identified or aggregate consumer information from the definition of personal information in the CCPA. If that sounds like a bunch of boilerplate, it kind of is, but it's very important. The definition of personal information in the CCPA is extremely broad. It includes not just somebody's name, email address, or phone number. It includes anything that directly or indirectly could identify that person. So we're talking everything ranging from IP addresses to identifiers you give the person. So if you assign them a specific number and then correlate all the data to that, facial recognition data, olfactory data, basically anything that you can think of that would be considered personal information or information in some way tied to a person, unless it is specifically excluded under the CCPA, and most of those exclusions are pretty limited. But nonetheless, it's helpful in that sense because if you do have de-identified data or aggregate consumer data that cannot be used to identify a person, well, businesses are going to use that to develop marketing campaigns to improve their websites, to take all these different steps. So in that sense, it's a positive, to say the least. Let's see, AB 1202, bad day for data brokers. So if you are a data broker, if you're selling data, or at least as data brokers are defined under the Act, you now must register with the California Attorney General. Yes. Now, if you were a paranoid individual, that might be concerning because one could imagine the California Attorney General might initiate an enforcement investigation where they just went down that list of data brokers. There's a lot of questions about how data broking is going to work under the CCPA, or even if it can. There are some provisions of the CCPA that are startling, very concerning, and may well effectively eliminate or greatly limit the ability to sell data of California consumers to other parties. So you're going to want to talk to a lawyer on that one. Very, very important. Assembly Bill 25, AB 25. This is sort of known as the employee exemption, although it applies to independent contractors and groups such as that sort. So one of the questions in the CCPA that's been brewing since it was passed is, what about employees? Now, you have to remember the CCPA was not a bill that was drafted and introduced to the legislature. Instead, it was an initiative that was created by independent parties. So it was very poorly drafted. And those parties, when they were writing it, they were only thinking about California consumers. They weren't thinking about businesses because, of course, businesses are evil. And So typically with privacy laws such as this sort, you will see a distinction or a subsection that deals with employees. If you interview for a job, so on and so forth. That doesn't appear anywhere in the CCPA. And so you get into this sort of strange situation where employees could exercise their consumer rights under the CCPA and ask businesses to produce things like all the data that they have on that person. And then you get into questions about, well, what would, does the business have to produce internal data where they're essentially evaluating an employee and saying, this is somebody who's a rising star, and we may well want to include them, on a progressive management track, or this person's, there's some questions about this person. What about a situation where the business might be thinking, hey, maybe this person is doing something illegal. We need to investigate this. So you get into all these difficult questions, and human resources, a lot of people in human resources probably would have just quit and walked out the door. Now, so AB 25 says basically that employee data, including independent contractors, is going to be excluded from the CCPA. So the CCPA will not apply to that. However, before you get too excited, this actually isn't the solution to this issue. So the California State Legislature, they passed the amendment, but the amendment's only good for a year. So at some point in the next 12 months, and probably sooner rather than later, this issue is going to be addressed again by the state legislature. And your guess is as good as mine as to what resolution they come up with. But that is something to keep in mind. Now, AB 1564. This is the consumer disclosure methods situation. So, again, drafted by private parties who didn't really think a lot of this through. But basically, the CCPA requires businesses to provide a toll-free phone number and an email address where consumers can contact the business to exercise their consumer rights. Now, it was then pointed out to a number of politicians that many websites online, as custom and practice, they don't have toll-free numbers. They don't have any phone numbers. Now, if it's an e-commerce store, something of that sort, then sure, there's going to be phone numbers. But what about a blog? What about a forum? What about social media sites or a video site? They're just not, the phone number is kind of antiquated when we're looking at the online environment. And so this bill basically was passed because it says that if you are exclusively an online business, then you don't have to have the toll-free phone number. However, that only applies in situations where you have a direct relationship with the consumer. So they had to add that on there. What is a direct relationship? Well, you can think of the obvious situations. Somebody buys something from you. Somebody signs up for your form. They're going to be providing personal information. That's a direct relationship. But things are going to get a little fuzzier. What about an affiliate relationship where they click through on your site and they go to Amazon to purchase something? Do you have a direct relationship with them because they're actually making the purchase from Amazon? Inquiring minds want to know. Assembly Bill 1146. Okay, this isn't going to apply to most people. This deals with vehicle information, specifically auto warranties and recalls. And it was a situation where manufacturers and dealers and middle parties between them need to be able to share that information so they can track data regarding the performance of vehicles and who's got what repairs and so on and so forth. And there were questions about whether that was allowed under the Act. And this exemption says basically, yes, it is. AB 874 just tries to streamline the definition of a term used in the CCPA in relation to government records. So under the CCPA, you can use information provided by the government, whether it be the Fed or the state or whoever, that is made publicly available. And this definition tries to clarify exactly what that means. And basically, it's essentially saying it's lawfully made available. It's, again, one of those areas where they tried to amend the law to make it clear, and I'm not really sure they did it. But nonetheless, those are the Assembly bills that were passed. Assembly Bill 846 failed, however. It's kind of a surprise, I have to be honest. AB 46 is addressing financial incentive and loyalty plans. There were questions about whether offering those types of options to consumers could constitute a potential violation of the CCPA is perhaps a violation of the anti-discrimination provisions or other areas of the CCPA. Seemed like a pretty straightforward amendment to me. I don't know why it didn't get enacted. Maybe somebody cut somebody else off in the parking lot or stole their parking space or whatever. But it failed. And so there's got to be a reassessment by companies. If you're offering financial incentives or a loyalty plan to consumers, well, you have to look at the CCPA and make sure that those are kosher. Because if they do violate the CCPA, then obviously it could give rise to a potential claim. Now, I have to be honest, I have some doubts that the California Attorney General is going to be particularly interested in this issue, but you never know. Always keep Murphy's Law in mind. So what happens now? Well, Governor Newsom has until October 13th, 2019, to sign each of the amendments into law. Are there chances that he won't? Sure. However, most of these amendments passed with massive majorities, if not unanimously. So it's somewhat difficult to see him rejecting it. Even if he did, the veto could probably be overridden. So I think that pretty much all 6 of these assembly bills are going to be enacted. And regardless of what happens, that means by October 13, 2019, we're going to have a definitive version of the CCPA text. We'll know what the code actually says. Hallelujah. And only 2.5 months before it goes into place and becomes effective. So that's going to happen. Now, again, we're also waiting for the California Attorney General to issue a regulation for the CCPA. Initially, there was a lot of hope that that's where we would get a lot of clarity on the ambiguity that we see in the act. However, after listening to some of the comments from the Attorney General, one gets a feeling that that may not be the case. Hopefully, I'm wrong. So we'll just have to wait and see what happens. So anyways, that's it for today's video. If you enjoyed the video, consider giving me a thumbs up. If not, I feel shame. Thumbs down. Feel free to subscribe to the channel. We're going to be posting all kinds of videos on the CCPA. You can also go to our page on YouTube, and we have a playlist for CCPA videos that may help you find answers to any questions that you have. So anyways, thanks for watching. Have yourself a good one.